8th annual Startup Boston Week, and I am Dhanvardhani here to host you today and excited to start the session. First thing first, let's give a huge shout out to Suffolk University Sawyer Business School for being our venue partner and hosting this amazing event right here in the heart of Boston. This location is the perfect launchpad to dive into Boston's thriving innovation scene, surrounded by industry leaders and groundbreaking ideas. And they have been our amazing partner last year, and we are lucky to have them again this year. Now, Startup Boston Week is all about connections, networking, and bringing together every part of Greater Boston and New England startup community. From every industry, every department, and every stage, bootstrapped or funded, there's something here for everyone. We have got 5 full days of learning here, networking, and straight up inspiration coming all our way. And now I also want to highlight that Startup Boston Week is driven by passion of volunteers. Most of them behind this event and those who are working today or volunteering their time. It's truly a labor of time and love, and we are so grateful for you to being here and contributing for the growth of our startup community. Once again, thank you all for being here at Startup Boston Week. Let's get ready to dive into Mallory Etchison's session on deploying AI, legal consideration after the initial surge, presented by Nelson Mullins.
Thanks for having me, everybody. I'm Mallory Atchison. As she said, I'm with Nelson Mullins. I chair our data privacy and security. We also do tons of AI work. So I've been helping companies implement AI for almost a decade now. And obviously, as you can expect, that increased significantly over the last couple of years. So we've also started an AI task force, which I'm a part of. And I'm excited to talk with you guys today about what we see with our clients and helping to get them to implement, to analyze, to stay in compliance whenever you're using AI. Have to do the standard legal disclaimer. This is not intended to be legal advice. It is not forming an attorney-client relationship, but happy to go through this stuff with you, and if anybody has any questions afterwards, I'm open to having a conversation. So to get things started, let's have a raise of hands. How many people in here are using AI currently in their startup? Less than I would have expected. How many people are considering it but just haven't kind of pulled that plug yet? All right, and anybody developing models? All right, got a few of everybody. Perfect. So that helps me to kind of go through this. We're going to go through a number of different aspects of this in things that you need to look out for, that you'll need to consider as you're kind of considering bringing in AI, how you might implement that, and then also kind of go through a little bit of the laws that might apply to you guys if we have time for that sort of at the end. So before we get to this, let's talk through the sliding scale, is what I like to call it, of companies that you're going to run into as you're considering or bringing in AI, right? If you go towards that left side of that scale, that's when you run into those free, open AI, public, all-use AI systems that many companies still kind of use. And then you go further to the right, and you've got more models that are designed for a specific industry or that have enterprise versions, and they might have more protections. Obviously, the more left you go, you're going to probably have less protections in the terms, maybe not be able to negotiate those. They're going to probably give themselves a little more rights to the data than when you get more to that right. So as we go through these issues, keep in mind that these might apply to you all differently depending on the size of your company, the company that you choose, the products that you choose, and if you actually negotiate any of these terms that might come with the products themselves. So given that, it is important to read the terms, I think is going to be a big theme here, because when this big surge happened, I had so many clients come to me and say, no, we're small. I don't think that we're using it. Let's do an inventory. And then they come back with expletives throughout their emails saying, well, almost everybody in the company is using a different one. They've all signed terms, some on behalf of the company, and we need to know what they say. It's super important to read those. I'll go through a few of the things today that you need to look out for, but I've left out things like liabilities and indemnification, meaning if you get sued by somebody that they'll step in and protect you, right? Get in that lawsuit. There's also things that aren't material terms like acceptable use policies. I run into that a ton with clients who sign up for something and don't read that acceptable use policy that actually says, hey, you can't use this for the reason you're wanting to use it for, or all the liability is on you, right? And sometimes those acceptable use policies will say entire industries. You can't use this for healthcare. You can't use this for law. Sometimes it will specifically say something like I had a client once that signed up for something that they wanted to draft marketing blogs, right? So they could get more of a footprint for themselves. And whenever we looked at the terms for what they signed up for, it specifically said, if you post this publicly, the first sentence needs to say this was drafted by AI, not me, which defeated the whole purpose of what they were wanting to do, right? You know, get your footprint out there by saying, hey, I used a AI to draft a bunch of marketing materials for you. So really understanding what that is going to be important as you choose what product is right for you and bring that into your company to know how you can use it best. So anybody who's followed the surge is gonna know what I mean by hallucination. The media took to this like crazy. I think it's a little overhyped for the scare that they try to do, but it certainly is a real thing. I'm a lawyer, so I put up here some of the stuff that they went nuts when lawyers started using ChatGPT and different AI and didn't check it and then submitted things to the court that were completely wrong. It's real. Hallucinations happen in these products. You need to be aware of that. I always like to show this because it makes me laugh, and it's kind of true, right? Is it safe to use ChatGPT? And the very first question is, does it matter if the output's actually true? If no, it's safe to use. If yes, there's some other boxes you need to go down. That's because these technologies are open about that. And in these terms that you sign, when you bring something on yourself, it specifically says, we hallucinate. Sometimes you're responsible for checking. You hold that liability. So back to the funny graphic, it's kind of true. Do you have expertise to verify that the output is accurate? If yes, are you willing to take liability for that? So when you're using something that's, prone to these things, you really have to look at your use case. What are you using it for? How important is it that it's absolutely true? And are you going to be the one to be able to verify that? Tends to be a business risk question, but it's certainly something that you need to consider. You also need to be aware of litigation. This is a really busy slide. It's intended to tell you that ever since this came out in the surge, there's lots of litigation around intellectual property, copyright, patent is going to be something we'll talk about. Privacy, did these models get consent for all the data that they're trained on? So far, the courts have really not been swayed by some of the plaintiffs' arguments here, but it's certainly something to keep an eye out for, right? Because if you are going to implement one of these models that are in this litigation, which it isn't just the big guys, right? There's definitely more that get these lawsuits as well. Or you might be using a small product that you think is small, but they're actually using one of these in the background, right? If that's the case, this is really important to follow because the DOJ and the FTC have said that they're going to combat this by something called algorithmic disgorgement. And we've seen them use it already in Everbalm. There's Weight Watchers, if anybody follows those. When they didn't get proper consent to put data into their AI algorithm, what they had to do was destroy it, right? Get rid of the algorithm that was trained on the data that you illegally collected. And so that makes a big difference for if you go down this path to invest in a model that something might come back and you can't use it anymore, right? So it's really important to understand what litigation is out there on the models that you're thinking about using. Now, let's talk a little bit about how you might use the models, how you might use the AI, because there's a number of different areas that you need to consider. Are you going to be needing an output that you're going to eventually want some sort of intellectual property rights for? Are you going to try to patent that? Are you going to try to get a copyright on that? That's extremely important. And it was one of the first things litigated whenever we saw this surge, right? And so thankfully, there's been some opinions on it. Got some information up here on patents. The patent office has actually come out to say you need to be a human to be able to actually have a patent. And a human needs to have significantly contributed to the inventorship to be able to have a legitimate patent. The funny thing about this is they're putting it on the practitioners who apply for this to really have done that before you apply. And they say that they can come back and ask you questions, and you need to be able to essentially show that you've done your due diligence in understanding who might actually have the right to the patent and that it's a verifiable patent. So if you are actually putting something into these algorithms, this AI, and input that you want the output to be yours, you really need to consider this. Going back to the terms as well, you need to look and see what you signed up for. Does it actually convey ownership for whatever the output is? Many of them do, but many of them convey any ownership that they can, right? Not all ownership, because do these models even really own the output? Goes back to the kind of copyright question. So it's a very detailed space that if you are trying to use this for something that's going to be really important to you in needing IP rights, definitely something you need to look further into and consult an attorney for. How many people in here are in HR or employment? Anybody? All right, this is really recent. This is just in the last month. It's not a completed case, but a judge did deny a motion to dismiss. Workday uses AI that would filter through resumes, right, and give you, as a company, the resumes to look at that met certain criteria. Discrimination laws are obviously really important in HR and specifically in resumes, and they sued saying that the AI actually discriminated because it didn't give past certain people, like it would automatically send a rejection, and so there was a lawsuit. Typically, that would be on the employer, but in this case, the judge actually extended the idea of agency, saying that that AI was an agent of the employer and could be held independently liable, which is huge for this space, right? We'll see how the case continues, but if an AI can actually be, or a vendor of an AI can actually be liable for their product, it's more important than ever for the company and the vendor to work together to have transparency, to understand what bias testing you've had. How are you monitoring this? From both ends, you both can be liable potentially. And so understanding how you're using it and not just setting it and forgetting it, automating it, saying I gave this out to a vendor, or vendor, I gave this to an employer, is going to be really important here.
Just confirm, so you're saying that Workday is potentially liable? The agents?
Yep. And the EEOC actually filed an amicus brief in this, which they said that they shared the same opinion, that they thought that the definition would actually expand. That's the language up at the top here, that it didn't matter that it was a technology and not a human doing it. You still delegated the same functions. So under the law, they read it as being able to impute that onto the vendor. Again, this was just for a motion to dismiss, so we'll see how the case actually plays out. But that was a really big, important happening that nobody's talking about, and it just happened this month. So keep an eye out on that one. Also, shameless plug, that AI task force, if you go to Nelson Mullins, we post a lot of blogs. I just posted one on this last week, and we'll keep everybody updated if you want to monitor that. So even if you aren't subject to a lot of laws, I have a lot of small companies who say, hey, I have only got a couple of people, I've only got a couple of customers, I'm not going to actually meet any thresholds for these kinds of laws. We'll talk a little bit about that. You might still be subject to these laws through your clients. We're seeing a number of different industries that will just go ahead and pass down those things. I put an example here. If anybody does government contracting, if you're putting in any bids, we've seen a recent surge of representations and warranties whenever you submit for that bid that specifically will make you have those kinds of obligations, right? That you have the responsible AI use policies. They may pass down some privacy things. So don't be thinking, I'm small, I'm just a startup, we're not going to be subject to these things. There's plenty of ways in which these laws might actually come back towards you. Privacy. That's always the first question that I get. from any client who is thinking about using AI. They say, what are they going to do with my data? And it's a really important question. It's a really hot space. There's tons of privacy laws being passed right now. There's tons being amended to emphasize the AI portions that they already had or to add them. There's also tons of AI laws being passed, right? And a lot of it has to do with the data and what you're doing with it. The most important thing here is to understand what data you're going to put into it. Because I've had so many people come to me and say, here's what we're going to use, we're looking at this product, and here's the use case. And then we vet that, and then they put it out there, and some employee says, hey, this is a really cool technology. Actually, I'm going to take this really sensitive data and put it in here now too. So you really have to understand, what are you looking at AI for, and what data could possibly be in this, so that you can look at the terms, so that you can understand your obligations for whatever that might be. And we'll talk a little bit about putting in some policies to help to maintain, I call it mind that pilot program, right? But it's really important, because if you have sensitive data, if you have regulated data, and you're throwing that into an AI system, you're going to need to know what they're doing with that. Going back to that sort of spectrum of companies, the closer you get to that left side, the more likely it is that those terms say, this is our data now. We can train on it, and we can use it for whatever purpose that we want to use it for. When you start moving more towards that right side, that's when you'll have companies that will come with a data processing agreement and say, this is actually your data. We won't train on it. We can put it behind your firewall. All of that good stuff. We've seen, luckily, that kind of emergence from when ChatGPT went nuts, and all of these technologies were saying, hey, no, if you want to use it, we get your data, to, okay, nobody wants to use it now, so let's try to give them some protections. But the protections they give are different. Again, you really need to read these terms, because your master services agreement or your terms of use you might sign will say one thing, and then a DPA controls in terms of privacy, and it'll say another thing. You really need to read that and understand, are they going to de-identify your data? Are they going to aggregate your data? Are they going to train on it? Do they have the ability to go in and delete personal information if you're going to give them personal information? It's important to understand what they think that they can do and what your obligations as a company are. This goes back to that larger question of, well, what laws am I subject to, right? And we'll talk through some of them. A lot of privacy laws in the United States have really high thresholds. So there's a lot of startups who aren't going to come anywhere close to meeting those yet. When you go more internationally, there's no threshold really. It's, hey, you marketed to Europe. You're trying to sell over here. So really understanding what you might be doing, what you intend to be doing in the future is really important. Some of these DPAs, they'll talk in terms of controller and processor, right? Controller gives everybody a good right to that data. They control that data, that's theirs. They control the means of collection and the means of processing. A processor processes that on your behalf, and so there's a lot more limitations there. If you're on the flip side of that and you're a vendor, I think there were a couple of hands there, understanding what you want to be. Are you trying to have more rights to the data? Are you wanting to be a processor? Are you wanting to be a controller? Really, again, looking at those terms and knowing what you're getting yourself into is important. Another piece of this is the product and the functionality, right? There are lots of things out there that will give you great terms, and you can use them, and they have liability and indemnification, and they've got the right privacy language, and then they say, oh, also, there's portions of this that are in beta testing, and if you use those, none of these terms apply. And it's in like a tiny paragraph somewhere, right? So if you've got 4 employees who understand what you're doing, you might not have somebody that sees a chat beta pop up and puts sensitive information in. You've gotten enough knowledge across the company, you know what you're doing. If you start expanding that to more people or not training to understand what you can actually use the AI for, you have more of a likelihood of somebody taking data and using those beta functions. They're not always clear. There's one particular huge company that does this, and they call them, it's essentially a beta feature, and the only way to know that it's beta and not subject to the terms is to go to their website and go to their release notes to know when it went out of beta and into a new one. So it's not like a big disclaimer that says, hey, if you use this, it's not subject to your terms. So really, again, understanding what you're going to use it for, what data you possibly could put into it, And we'll talk in a little bit about training your company, having policies to make sure that that stays is really important here. All right, so we talked a little bit about what privacy laws might apply to you. It's really important with AI. These are all portions of privacy laws that you might be subject to. And so understanding how your use of AI is going to go with these is really important. You have to have informed consent. I have a lot of companies who have collected a vast amount of data, right, or weren't subject to laws before, and they want to now put it in AI. You really have to think through, did you get the proper rights to that to begin with? Do you have to re-notice customers? How are you actually going to be able to put this personal information in or this data in to a model and have complied with what you need to comply with? Transparency and logic, that's a big part of what we're seeing come up in these laws. Being able to adequately describe to regulators, to your consumers, whomever it may be, how it's working and what you're doing is extremely important. Privacy by design is being written into basically all of these laws at this point. So if you are building, you are one of those people, making sure that this is at the forefront and not something that you'll deal with later, right? It should be a core consideration as you're building. It's not something that you just get to pass down and say, well, whoever's using this, it's your responsibility. So really understanding those core concepts is going to be important. Data protection impact assessments are really big. That's coming into a lot of AI laws. That's coming into a lot of privacy laws. Essentially, before you would use your data in these systems, doing an impact assessment, understanding what the risk of that is going to be, potentially getting that in writing. There are some states that are trying to make that be something that an attorney general of a state can actually see. We're looking at the constitutionality of that right now, but understanding really how you're going to figure out, is this a high risk for the company? Is this a low risk for the company? I made these decisions to implement or not implement these privacy protections. Let's document why, right? Data subject requests. We talked a little bit about that, but these privacy laws have the right to know what data you have on them, to access the data, get a copy of it, to potentially delete that data. If you put somebody's personal information into AI, can you delete it? Is it still there? Depending on the vendor that you choose, some of them draft into the contract that they'll do this if they can. Some of them say they can do it. Some of them just flat out say they can't. So understanding if you have obligations to this, how you're going to fulfill yours if you've now implemented a vendor who might not be able to help you fulfill that. Security is also big. Data breaches are huge these days. So understanding not only your own security and how you're protecting any data that you have, but how that flows down to any kind of vendor is really important. Like I said, some of them you can bring behind your firewall, others you're going out to, so ask those vendors for that security documentation. At this point, the reputable ones all have that on the ready, right? They can give you that to give you that comfort, which also gives you that due diligence process. And we talked a little bit about algorithmic disgorgement. So keeping that in mind, that appears to be a big way in which they're going to combat this. So making sure that you've got this right before you start that process and invest in it is going to be really important. So you've decided to use it. Now let's talk about laying the groundwork a little bit. In general, I like to tell my clients, this is like stupid simple, but it comes down to the point, right? There's a 3-point strategy here. Identify the use case that we're talking about, identify the products that you want, and then figure out how you're going to execute on that. That's going to contain internal processes, which is going to look different for each of you. A smaller company is going to have a lot different of a process than a larger company, but it's really important to start thinking about this early on, right? And thinking about how you're going to grow and how you might not do these things at the moment, but you might need to start thinking about them as you start investing more in AI, as you start growing your employee count, as you start growing your customers, the sophistication of your customers. These are things that you will want to implement. You'll want to have these to get around a lot of the protections that I've been talking about. I mentioned earlier, Mind Your Pilot program. I think that this is so important because, again, I can't tell you how many clients have come and they thought that they were contracting for a specific use case, and then it went beyond that, and then the terms no longer protected them, or they violated a customer contract that said that they wouldn't do X, Y, and Z, but some employee did it. It goes to the training too, right? Even if you have a small group of people, it's so important to have that training. As that grows, you have more likelihood of a rogue employee putting something in, but even a few people, you really need to have everybody understand what you're using this AI for, what data is allowed to go into it, what responsibilities and obligations that you have, so that as you're using that, you stay in compliance with what you thought. There's going to be a lot of business risk decisions as you're contracting for these things, but if you go outside of that pilot program, that intended use, then your whole business risk analysis might need to be redone, right? So mind that pilot program. As you grow, invest in training. That might be an annual PowerPoint presentation or a call or an email, a security email, or just the team that you've got siloed to be able to use this is trained on it. It doesn't necessarily have to be the whole company if not everybody's going to have access to it. Reviewing and, I say if possible, negotiating your agreements. As you grow in size, you're going to have a lot more leverage to negotiate. Don't ever think that a company is too big to negotiate with. I don't think that there's any of that big tech list that I haven't got to negotiate for the right client position. So make sure that you read and you understand what you're doing. And if something doesn't work for you, see if you can negotiate that in. See if you can redline that, right? There's a lot of these that are legal and you'll need to ask a attorney for guidance. But there's also a lot of these that are business risk that you might be able to get them to agree to something else. Make sure that you understand the totality of your agreement as well. Because again, if you get terms in a contract, a lot of times it'll make it seem like it's just that, and then they'll have links to other things. Some companies are notorious for saying, oh yeah, we'll take liability for this, but they put it in a blog and don't actually even incorporate that into the terms, so it's not a legally binding provision. So understanding what your agreements say and negotiating. See if you can get that blog put into writing in the contract. See if you can incorporate that somehow. If they don't have the security measures that you need, redline in the security measures that you need. If they're not saying that they're going to indemnify you for intellectual property, see if you can get them to budge on that. Again, as you grow, you're going to have more negotiating power there. But I've even had small companies, for the right clients, be able to negotiate these. If you're going online and your clients or your employees are just going through a click-through agreement, those aren't negotiated, right? You just agreed to all those terms flat out on there. So another important thing is to have a process for this, right? There's lots of big companies that have huge vendor procurement processes in place. You all might not, but making sure that your employees understand, hey, before I sign something, this needs to go through the CEO or the CISO or whomever it might be, so that there's somebody with knowledge of everything that you've agreed to and that can pause somebody before clicking right into that. There's benefits of that for a number of things, right? For one, understanding the terms you're subject to, but I had a client recently that didn't even realize 90% of their employees had signed up for things and they didn't have an enterprise agreement, even though they technically could have at that point. So they get better pricing, better terms by bundling that into one enterprise agreement instead of all of their employees having separate accounts and signed up for separate terms. So really making sure that you understand what that is. Human in the loop is a really big thing, right? That's a term that you'll hear over and over, but don't just delegate really big decision making, just like the HR case, the Workday case, right? If this is something that's really important, have a human in the loop. Make sure that you're reviewing what comes out of that. Make sure that you're not just wiping your hands and saying, hey, I used AI for this, because the laws aren't going to let you do that, right? So generally, review that output if you can. Understand what's going to happen if you don't. And become familiar with the responsible use standards. As I said, even if you're not going to become subject to one of these laws because you're not meeting any kind of thresholds, you might for your client contracts. We'll talk about the executive order in a little bit. You might say, oh no, I don't work with government. But one of the things that Biden said was, hey, NIST, get me some new standards. NIST flows down to everybody in the private sector as well, right? If anybody has a contract with security, most sophisticated clients will ask you to have some sort of NIST program, right, in place, something that mimics that. So as those types of things build out for AI compliance, for responsible use standards, we're going to see that trickle down to everybody in terms of contracting, right? ISO certifications, SOC 2 certifications, all of these things flow down, and we'll see that in your business. So draft internal policies and follow them, right? This looks different. Again, depending on what your size of your company is, what you're choosing to do. I have clients who are large enough where they've got AI committees to review things. Like I said earlier, there might be a vendor process that goes through that. You might already have a procurement process in place. Add the AI into that, right? Or you're small and you might just need to go through the inventory that you've got right now, figure out what you're using, figure out what you're planning to use, and draft something simple. Your AI internal use policy isn't a static document that once you send it out, that's it. This is something that you'll update over time as you grow. One of the sections that I always put in mine is, here's the tools that you're allowed to use, right? And here's the tools that you're not allowed to use, and here's the tools that you're allowed to use partially. And that grows, that changes. As you sign better contracts, as people get more protections in place with vendors that are even on the free ones, that might be a list that's ever changing. But if you've got a document that you send around that you might get signed by your employees, that you might just be giving it to them, then they understand what you as a company intend to have this AI use for, and it protects you in those areas that we were talking about, right? In, hey, don't put sensitive data in this. If you need IP rights, don't ask for it from this particular vendor, right? Don't put it in the chat. Don't do whatever it might be. These can be very detailed. It can be a policy that says, hey, don't use AI at all, right? Like, we're, as a company, saying, no, we'll let you know if we can use it, but for right now, don't use it. I've seen varying degrees of that with my clients over time, and all of them, again, update as they grow as a company, as their risk tolerance grows as a company, whatever it might be. So I put just some things that I would typically put in there, right? Purpose, define, make sure you're defining things so that it's clear. When your employees read that, they understand, and not just, oh, well, what's generative AI? That could be anything, you know? What's AI? That could be anything. Make those definitions so that it's very clear what your policy is for and what you're trying to do with it. Again, I put training in here. I think that's really important. If you can handle it in-house, there's also plenty of vendors out there that can help you with training, but make sure that you've got things in there that they know what they're supposed to be using it for, what they're not supposed to be using it for, and if they want to use it, how to elevate that. Is it email this one person? Is it email this whole domain? Is it raise it to your manager? Whatever it might be, make that clear so that you protect your confidential information, you protect your intellectual property, and you protect those prohibited uses that you might have a contract that says you can't do something or a law that says you can't do something. So, want to quickly talk through some of the laws that might apply to you, right? I have small companies all the time tell me, well, even if I'm subject to that law, I'm small. Nobody's going to come after me. Maybe, maybe not. I have lots of companies who have received, questions from California, questions from Texas, just for their privacy practices or for consumer practices, right? And we'll talk a little bit about that. But the states care about this. This is something that's on everybody's mind. And so we are seeing wide nets being cast. You might not be the one to make the media and say, hey, we had a $5 billion settlement with them, but that doesn't mean you might not get a CID or a request from an agency that asks you how you're dealing with things. And even some of these laws are building in private rights of action so that your consumers can actually sue you. So just because you're small does not mean that this is going to fall on your wayside, right? You need to be aware of this. You need to be aware of when you might meet these thresholds and what you need to do. California CCPA, I'm sure most have heard of it if you do anything in privacy law, It was the big one in the United States. It mimicked GDPR in a lot of ways. It's very restrictive. It's got a lot of requirements for consent and notice and all kinds of practices. It built in AI to it when it was promulgated in 2020. GDPR has AI stuff in it already. We now have, I think we're up to 17 states who have comprehensive privacy laws, all of which are either already included AI or are proposing some sort of amendment related to AI. You also have a lot of very industry-specific things that are happening, right? Healthcare, if you have healthcare data, there's lots of laws being introduced or passed even with regard to safety in healthcare and AI. There's lots of lawsuits in healthcare data and AI right now. This is from the CCPA. They put in AI when they wrote it, but then they didn't actually write anything around it. So then the resurgence made them kind of come up. And things that they're considering once this potentially passes through might be pre-notices that you're using an AI algorithm, giving people the right to opt out of things. Like I said earlier, that access right. If you have any data that's on a minor, that's super important right now. It's written into almost all of these AI laws, and then there's also a ton of federal and state laws that are making sure to protect minors' data. And if you are targeting minors, even how you get that data is really going to be important over the next couple of years as we see those laws kind of build out. Colorado is one of the states that have actually already passed a law on AI specifically. The EU AI Act, which will be my next slide, they're very similar, right? They've got all these categories of AI. Is it high risk? Is it a general purpose use? All kinds of things that you'll have to take a look at what you intend to do and classify yourself where you think that fits. And each of those is going to have different responsibilities and obligations with that. Some of them have exceptions for smaller companies. Some of them have partial exceptions. Like this one is just a partial exception, right? If you have fewer than 50 full-time employees, you don't have to do the risk management program. You don't have to do the impact assessments, but you do still have a duty of care, and you do still have consumer notification requirements. So again, going back to knowing what's going to apply to you. Colorado isn't the only US one that's got AI laws passed. I think we have 4 or 5 now, and there's plenty that have been proposed. The federal privacy law also has a whole snippet on AI if that ends up passing. So being aware, either yourself as a company, hiring somebody who keeps track of this, asking your law firm, hey, can you keep me up to date? I have plenty of clients that I just send out these notices to, hey, this one passed, it might apply to you, right? We're keeping an eye on this. Really understanding what these are is going to be important. I put some of the obligations on here because they do tend to get really intricate, and they're probably going to be costly to some organizations who didn't prep for it in advance and are trying to rush through it, right? The EU AI Act, if you are targeting Europe, if your algorithm is going to target Europe, if your algorithm is going to affect somebody in Europe. This passed recently, took a while to get through all of the laws that EU has to actually get it in effect, and it's going to have these same categories of unacceptable risk. It's going to prohibit AI in a number of different industry sections in using it for specific things that it just deems to be too high risk to actually allow. You need to know if your use is going to fall in there, right? Because you might only be in the US right now, but you might have goals as a company to expand. And if you start your AI initiatives now, you need to understand if you're actually going to be able to expand globally. Then you've got high risk, limited risk, minimal risk, and the general purpose AI, those big chat platforms, right? All of these have different obligations with them. There's, I think it took out the timeline, but it's phasing. They're going to have, within 60 days, some of the requirements go into effect, and then another 180 days they go in through a few years before it's all fully effective, right? But it's already passed. So if you are marketing Europe, you need to make sure that this is on your radar if you're going to implement AI. Consumer protection laws. Talked a little bit about this earlier, but you're saying, hey, I don't meet the privacy comprehensive thresholds. I don't have 100,000 California residents, or I don't have the revenue threshold, whatever it might be. But states are getting creative. Texas, if you've seen any of the big headlines from Texas lately, they're not suing under their privacy law that has threshold limits that are really high. They're suing under consumer protection laws, which is much, much easier to fall under the purview of, right? And so they're also adopting these specific laws that go to that. Are you being deceptive? Are you violating consumer protection laws? So again, it doesn't matter how small you are, we are promulgating as a country laws that are going to impact you. We talked a bit about Biden's executive order as well, right? This was definitely aimed towards government contracting, but in it, it's 110 pages of a lot. So if anybody's bored and wants to read it to sleep, I encourage you to actually read it. But it essentially asked all of the alphabet soup agencies to start doing certain things, right? To start a task force, to look into promulgating some sort of regulation, all kinds of things. And we're starting to see that play out. We've seen NIST framework update. We've seen agencies come out and say that they've already started their task force. So as this progresses, we're going to see all of those DOJ, FTC, CFPB, everybody that you might fall under that purview of, even if you're not contracting with the government, start promulgating these regulations, right? Again, plug for our NM task force. We are making sure to post blogs as this happens because this is something that you're going to need to stay on top of. Similar, we're now seeing states pass executive orders, right? It's a big area. Politicians want to do this. And so we're seeing tons of states that are starting to pass executive orders. All of them have differing things in them, right? If you are in a state that has one of these, you're going to want to read what that executive order is, because it might require you to have those responsible security provisions. It might require you to give some sort of notice. And each one of them, again, has just been sort of different, but similar in that we are trying to put forth transparency, trying to put forth rights to consumers to understand what you're doing with their data and to elect to opt out of it. And like I said, there's also lots of domestic initiatives going on. NIST, the FTC has put out a lot of questions to that big tech, right, and how they're doing. They're trying to look at things from a monopoly standpoint. They're trying to look at things from a security standpoint. We already have lots of lawsuits happening from the FTC as well. So keeping an eye on any of those agencies that you might be subject to, that you might fall into their purview, understanding what they're doing, because I guarantee you they've released some sort of public statement on how they feel about it and what they're going to do to regulate it. So I wanted to leave time for questions. I'm up here if anybody has anything, but yeah, thank you guys for having me.
One question. So human has to create patentable art. I'm curious about the role of AI and prior art.
And meaning that you've submitted something and,
And
you wanna know
whether
if there's a
AI has
prior-
already created it. So obviously human needs to create the patentable asset,
Sure.
but what if AI has already come up with it? Is that considered prior art?
AI cannot have a patent. That has been the opinion. So you're not going to have a prior art that was violated if it was just AI that created it. Now, if somebody substantially contributed to that and filed, then you've got your prior art.
What if it already
analysis.
exists in market, not patented?
I mean,
Can you still patent it?
I think that's I'm not a patent attorney.
Yeah.
I think it's going to be a very factual question, but I think it's usually a first to market, right? First to race, and did they have something that they could actually patent? It sounds to me like what you're asking is no, they didn't. If it's just AI that created it.
Correct.
Yeah. It's going to go back to right here, their guidance. And this is not just in the US. I did this, but we've also seen internationally different patent offices come out and say, right, like it has to be a human. Any other questions? You have a
I'll
microphone.
go first. So, do you have any idea how closely the regulatory space right now is for allowing growth and innovation in AI applied to business operations?
I mean, I think that that's just something that we're dealing with as a country. The laws that are being passed are tending to be more favorable to growth and innovation, right? You look at the EU AI Act, and that is so strict. And I mean, in terms, so is GDPR with privacy, right? Like that's just Europe. They're going to have a lot more regulations and requirements. And if you read Biden's executive order, it's definitely still encouraging growth and encouraging that innovation. We do see some of these state laws that are starting to tighten that up a little bit, but I think as a country, the laws that are being passed are trying to make sure that we still have that for a competitive edge in business as a country in general. I mean, you know, I have a lot of clients who have a sentiment of how easily are we even going to be able to market in Europe for too much longer if it costs so much to comply with everything that they're putting on us, right? And you see these huge fines coming from Europe, but we haven't seen as much of that in the United States. I don't know if somebody else had a microphone.
Hi, thank you so much. This has been super helpful. I work at JP Morgan, and we're lending to companies in this space, and as an investor as well in space, like, how do you think about all of these new regulations as every single company is throwing out AI products and features? Like, how do you make sure that those companies that you're lending to or giving money to, they're not stumbling over some of these new laws and getting hit with some big fines?
Yeah, I mean, that's a really good question. We've seen various approaches to it, right? I've seen a lot of companies who sent out even an email at first when everything went crazy and said, hey, as a reminder, you weren't allowed to use our data in AI without our permission, or emphasizing that in your contracts to make sure that they understand. But certainly my larger clients are doing this really big vendor analysis of what vendors do we have that are using AI as a product, what ones, like you said, are introducing just functionalities that use AI, and how do we feel about that? That goes back to that process of understanding where your data is and having the right agreements in place to protect that, so that if something is happening and you're subject to these laws, you're doing your due diligence now to understand where you need to risk mitigate, right? Where you need to stop using a particular vendor. Or I've had some that send messages saying, hey, we've added AI functionality and you have to opt out, right? Instead of opt in, because it used to be opt in and now they're starting to do opt out. And so having somebody in those contracts that says, any change in this, you need to email this domain. We need to have notice within 30 days, within 60 days, whatever it might be, and then we can terminate that portion of the agreement or whatever it might be. If you already have those contracts in place, it's renegotiating. But a lot of times we already had that language. And so going back and making sure that you're using those contracts to know what happens with your data and what you can stop is important. Did that answer?
Hi. So I had a question for startups that are augmenting existing AI technologies. Let's say, for this case example, ChatGPT. Like currently, there is an option when setting up. Sorry. There is an option when setting up a custom GPT in which, if you upload like a blank TXT file, you can turn off sending training data to OpenAI.
Yep.
How much should we be like saying within our privacy policy if we're building tools like this in which your training data isn't being sent by default, like with the privacy policy? Should we, since we're using OpenAI, for example, or Claude or something else, even if we're saying we're not, your training data isn't being used 100%, do we still need to like follow their privacy laws or like the policies and put in ours?
It's a good question. So it depends on what you're going to be subject to, right? Because each privacy law is different, which is why we have 17 of them to make everything complicated. But some of them might require more transparency than others. There is a feature with even a chat GPT that you don't train, right? The models, and that's great. That's a good step towards understanding that your data isn't going out there. But some might still choose to disclose that and say we use AI, but we don't share your data. We don't train on your data. Others, if it is training, then you need to probably have that disclosure in a privacy policy. But looking at your terms with OpenAI and knowing, okay, it's not training, but sometimes it's that it doesn't train, but we're going to keep your inputs for 60 days and somebody can review it for fraud or for whatever. So you're still going to have a human eye on that, right? If you have really sensitive regulatory data in there, that might still be a problem. So you've seen these vendors start to switch to, okay, but you can also apply for an exception from something like that. So it's not as simple as we're not training your data. It's, not going to our larger model. It might still be that your data is going somewhere, is being reviewed by a human, is being kept somewhere, and that might or might not be okay within your organization, depending on what you've got.
Yeah, so like we're trying to go for the SOC to ourselves, and like the person that we're working with mentioned that even if we're passing off the security decisions and everything, building it on the LLMs themselves for the client and whatnot, we can still possibly be held liable as like saying these are our contractors or something else like that.
Absolutely, right? Like you've got contracts that will say you will pass on certain security provisions to your subcontractors. And so just because you're using something else, going back even to the HR stuff as well, right? You can't just wipe your hands of that. And that's not new with AI. That's everything that you've got. You can't just say, well, my subcontractor did it, so I'm not liable for it. So yeah, making sure you do that due diligence, that you get, like I said, ask them for their security provisions. They're going to hand it to you. It might be confidential, and they might not want you to pass it around. It's going to be in a PDF that you can't redline, but they'll give it to you so that you can get that comfort level and understand if it fits with your obligations currently.
Hi. How are you advising with users, with all the different regulations happening on a state-by-state basis for interstate use? Is just everything, regardless, it all kind of builds into one
Really
regulation?
obnoxious, right?
Yeah.
So typically my approach is to group where you can, right? It used to be a lot easier. Like right now, let's say a couple years ago, we only had 5 in effect, and all of them were decently similar. There were a couple of aspects that would add little things, like a ban on targeted advertising or something like that. So it was easy to group those together and pull out California because California is California. But as we are seeing more pass, what I've noticed is they take the best parts of each of those privacy laws and include it. I do think we're going to get to a point where you'll be able to have a more one-size holistic privacy policy that just covers all of the things, and then maybe your consumer rights section might have to be divided up if a state says specifically you have to call us out by name or gives an additional right or something like that. But we are starting to see them be a little more cohesive, and then potentially the federal law got some traction. So I don't think we'll see it pass soon, being an election year and everything, but if it does, one of the big questions of that is, will it preempt all these state laws and get it more of a GDPR? As obnoxious as GDPR is, at least they have one law that they have to comply with, and right there, you don't have to go through states. But it's definitely something that it depends on you as a company. I also have some clients who will just choose to comply with all of them even if they don't meet those thresholds, because it's easier for them operationally rather than trying to find out, well, where do you live? And I need to do this. But then you're adding more obligations to your company than necessary. So it's a lot of a business risk question too.
Hi. In the HR world, it seems like a lot of the concern around utilizing AI is around bias and mitigating that, but not a lot of attention on deciding how much intervention should be required in a lot of the processes, like the Workday case.
Yeah.
Have you seen any laws come out on a state basis that kind of dictates that?
Meaning how much human interaction you need.
Human intervention is required in like the hiring process.
I don't think I've seen anything specific saying you have to have somebody 20% of the decision or something like that. Like that would just be really hard. I think that whenever you're looking at your approach for it, it will be very factual, right? Like what are you using it to deny people employment? Are you using it for aggregating all the data that you already have? Like each use case is going to be different for how much you really need that interaction to be able to comply with different laws. I think the Workday case certainly emphasizes that you're going to need that human in the loop in specific areas and that you can't just say there's nothing, but it doesn't yet tell us exactly how much. It will be interesting to see that case play out and see what the arguments are, because Workday in their initial response is saying, hey, we don't actually do all these things that you think we do. We're not biased, we're not this. And then obviously the employer, if they get something, is going to say, wait, we did X, Y, and Z, this should be on Workday. And so it'll be really interesting to see if a judge speaks to that in the case.
For sure.
All right. Nothing else? All right. Well, thank you guys.